Welcome to Thinking Like a Lawyer with your hosts Ellie Mistal and Joe Patrice, talking about legal news and pop culture, all while thinking like a lawyer. Here on Legal Talk Network.
Hello, welcome to another edition of Thinking Like a Lawyer. I'm Joe Patrice. Welcome to the new year. Thanks for joining us in this new year, and also thanks to our sponsors, Smith AI, the virtual reception service for lawyers, and U.S. professionals answer your phone and website chats. They're very useful, and you can schedule appointments, so you can get a free trial with Smith.ai. We'll talk a little bit more about them as we go on, but they're sponsoring this show, which is just me and not Ellie, who is not here at all. But Kathryn Rubino, also of Above the Law, is here to fill in for Ellie, so welcome.
Hi, folks. How are you doing?
Yeah, no, you've noticed we've been absent. That's because we could not find any time where Ellie was around between travel issues and him getting ill, and now he's at the law professors conference. So there's just was never any good time to get everybody together. So Kathryn's thankfully stepping in to allow us to have a show. So thanks for that.
Well, my New Year's resolution is to be kinder to my coworker, so I really had no choice when you asked.
Wow, that's good to know. That's good to know. And for those who don't work here, that's a very significant New Year's resolution that I'm sure will be broken, possibly before the end of the episode.
Try not to tell too many people.
No one's going to listen to this podcast. It's great. So it's not like we have an audience or anything. So we're here to talk about the new year and a few stories that have happened since we last checked in with you. Do you grind gears? Do you have anything that you're annoyed about?
Well, I probably won't yell like Ellie, so that'll be a distinction. But yeah, there's definitely some stuff that have been annoying me. How about you?
Yeah, sure. But see, like...
No, well, but there was a story that, we recently ran on Above the Law. What?
No. How often do you listen to this podcast?
Pretty frequently. I mean, in fairness, you generally record in the office while I'm in the office, so I hear it as it's happening most of the time.
Yeah, there's a format here. There's a thing. Like, you complain about something that's totally unrelated, and then we banter about it. Like, come on, man.
Well, my Christmas lights are still up, and I actually don't care. I think that we should actually keep our Christmas lights up through February. We're getting to like the ass pit of the winter months, and I feel like Christmas twinkle lights are pretty much the only thing bringing joy, and everyone should keep them up until the ground melts or something.
Yeah, I actually read a thing the other day making the argument that we really need to move Christmas later. We should just all make the concerted decision to the extent that it probably does not actually reflect any specific date, but was rather just kind of chosen by the church, and it's therefore flexible.
Are you telling me Jesus was not born as a Capricorn? Is that what's going on?
That is what we're saying. Yeah, and so to that extent, it probably is a smarter move to move it to the middle of the winter rather than 4 days into the winter, because you would have something to look forward to.
It's so true. The weather is crap. Yeah. There's no chance anything's melting, or we're going to have snow and cold and wind for another 3 months in all likelihood. The only, kind of spot of joy is a little bit of Christmas cheer. It makes total sense if we move it. I mean, it'll never happen, but, it'd be great.
Yeah. Well, maybe we can move Festivus. So, okay. So there. See, that was a worthwhile grinding of gears.
Well, it's the best I could do.
You did okay. All right. Well, good. Well, let's take a quick break. So, listeners, are you missing calls? Are you spread too thin? Interruptions kill your productivity, but clients demand a quick response. The U.S.-based professional receptionists at Smith AI help law firms screen new clients and schedule appointments by phone and website chat. Plus, Smith AI integrates with your software, including Clio and LawPay. Plans start at just $60 per month. Get a free trial at smith.ai. And we're back. So, Kathryn, what stories have been happening in the last couple of weeks that you find interesting for all the listeners following the legal landscape?
Well, there was one fairly recent story, and it's kind of a kind of cute, seemingly innocuous kind of story. But the more I think about it, the more it kind of sticks in my craw and makes me really pissed off. There was a recent Supreme Court oral argument, and the attorney in the case, Trevor Cox, he gave the oral argument while his wife was in labor with their child. And it's kind of been going through Twitter and people referring to it as an impressive humble brag, or somebody else wrote that it may be a humble brag least worthy of being humble. But it just kind of pisses me off because, a woman who was giving that oral argument would have no option to work through the labor of their child. And it's really only a privilege. It's only something that men get to do, is to kind of be that kind of diligent, hard worker that puts their family life on hold in order to, do an impressive thing with their career while their wives are busy giving birth. And that's not something that, every person gets the opportunity to do. And I don't think it's something that we should be exalting as some positive or something worthy of or some sort of a humble brag or something like that. I think we need to be like, hey, that's kind of messed up. We should never ask anyone to do any of those things. And the more we kind of hold up this as a model of look what this guy did, when we know for a fact that women or people who are able to give birth are not able to participate in the same ways, it's just holding up an ideal that is never attainable for everyone. See, I told you I get really pissed about this. The more I think about it, the more angry I get.
So your stance is that we should, as a legal culture, we should not allow, we should certainly not encourage and potentially not allow men whose partners are expecting to give birth to be forced to do work, right up against that.
Yeah, I mean, it just it speaks to the whole culture of, elite legal practice, that we are willing to ask people, whether it's explicitly or implicitly, to sacrifice parts of their personal life in order to be the very best at this. And if we don't come to some sort of recognition of the ways in which we are asking, what we ask in order to be elite is only something that people who are not pregnant are able to be and able to do. And then we wonder why the amount of men giving oral arguments at the Supreme Court far outweigh the number of women. While even though, we have more women entering law school, fewer of them are becoming law firm foreign partners or giving these oral arguments in all sorts of appellate situations. These are all part of the reason why. There's a whole landscape of reasons, and certainly changing one thing is not some automatic cure. But I think we also have to be very aware and wary of the times when we see something that is part of the problem. And it's more than just, he got to give an oral argument while his wife was in labor. But, think about a woman who's in a firm, or somebody who could potentially be on a case that might, want to do this sort of thing. Are they put in a position of being forced to delay their family plans? What if they do become pregnant as they're, on a case that may get to be argued in front of the Supreme Court or any kind of big appellate court? Are they being put in a position of being like, I guess we'll also staff it with a male client just in case, you have to give birth at the time. And these are the sorts of opportunities that are being taken away from women because we see pregnancy and families as a detriment to the elite practice of law.
Well, that was a thing earlier this year. There was some firm that tried to file sanction motions against another firm because the woman who was leading the trial team of the other firm asked for a delay to give birth, and so they filed for sanctions for her trying to screw this up. Yeah.
Yeah, and I mean, that's kind of, I would certainly hope too many people and firms and lawyers aren't taking it to that extreme, but it's even these kinds of little things that, this guy had a ton of pressure on him as he's, waiting to see whether or not his wife's status of her labor as he's giving oral argument. Look at all the pressure he's able to withstand as he's also being peppered with questions by the court. This seems a lot less awful, certainly, as someone who's asked, lawyers who ask for sanctions just because a woman, asks for a continuance because she's pregnant. But these are all the sorts of small things that make up a landscape where women are increasingly checking out from these sorts of positions.
Yeah. definitely, because I'm sure it turns out that he didn't tell the court that this was going on. He only let it slip after the oral argument was over. He, reporters learned of it. Yeah, no, it's rough. I mean, he probably should have been back there, in the waiting room smoking a pipe or whatever it is men do these days in that sort of situation. But yeah, no, that was what he did, and it wasn't like it was some DC Williams and Connolly partner who was, down the street. It was a state away. Mm-hmm. Yeah.
And I'm sure this guy is great. And I'm sure, he's just trying to do the best he can, being, a parent and being a lawyer who's arguing in front of the Supreme Court. And I don't mean to direct any of the, concern I have about it at this individual, because people make difficult choices all the time. But we have to sort of think about why we're making the choices we make and how we choose to talk about and report when these sorts of things do happen. I think we need to be very aware of the fact that, as cute of a story as it is that, this is what he did, it also, we have to recognize that it's not a luxury that a woman attorney would have in the exact same situation.
Oh, yeah. No, and that's a good point. That it's not so much that he's done anything wrong here. He's done, in fact, what he would have been expected to do. I don't think that the powers that be would have expected him to do anything but this when confronted with the opportunity of, representing a client in this case. Right? In this case, it was a state, right? Yeah, and in front of the Supreme Court. Yeah. Anyway.
So is there any recent stories that have kind of stuck in your craw that you want to talk about, Joe?
Yeah. So also kind of on the culture being broken. This one comes out of the University of Michigan's law school. They had a situation, like most schools do, where in accordance with a lot of the legislation from the Americans with Disabilities Act and just generally how schools try to deal with potential discrimination, they make accommodations for those who have any condition that could be construed as a disability. For getting a test completed on time, they will afford reasonable accommodations up to and including extra time for those folks to finish their exams. That's all well and good. It's fairly common practice among law schools.
Law schools, undergrad. I mean, I think that this is, as you were saying, a very common practice.
Some student that we don't name, because our policy is generally speaking that students are allowed to be morons. And we give them the opportunity to get themselves back on track. Some student wrote to the school-wide comment board that, these people were ruining the curve for him. So
delightful.
Yeah. I mean, it is the kind of dumb thing that happens out there. There are people who, especially at 1L level, who are A, unnaturally worried about their curve, and B, not yet ingratiated into common sense enough to understand what reasonable accommodations are and how important these are for folks who just need them to be on the same playing field as other folks, not because they aren't capable, but because there's one thing that they need, they can't do certain things at the same pace, and so that needs to be addressed with a reasonable accommodation. So that was the story. Afterwards, though, is what I'm more interested in, because after I wrote this story, I think everybody kind of agreed this was a bad thing that the student had done, complaining about it. The university was quick to point out that that didn't reflect their values and why they did what they do, and that was all well and good. What was more interesting to me as somebody who writes on the internet and has kind of a public life like that, finding people who can point to and show me new ways of thinking about stories that I may not be in a position to see or understand. So one of the things that was interesting to me was there was initially some pushback over my use of language like disabled in the piece, which that is a difficult one, because there are people who suggest that there's problems with utilizing language like disabled for folks who you have these various conditions. That said, I did what I did because as far as utilizing that language, because that is the language of the statutes and the regulatory regime that is at play here. But it does create, I mean, it's a iffy place though, like at a certain point as a journalist, I'm reinscribing that sort of rhetoric by utilizing it. Now, granted, I'm doing it because that's what the law is, but that I bear some responsibility for the language choices I'm making too, right? So that was an interesting thing, and it's always good as a person who writes out there to be self-reflective about whether or not, I'm not altogether sure I would have changed that particular usage in a different situation, but it was important to understand that is a concern and to be able to flag it,
Sure. So you were saying that, there are some people who have responses to our articles that, really feel like it helped you develop some of your thinking on these issues. Is this one of those cases where, so you had some nuanced conversations with actual readers that weren't just a onslaught of hate mail?
Yeah. No, absolutely. I did. There were some folks who thought it was awful or whatever, and I addressed them, and some responded, some didn't. Others, though, came in and said that actually, from their perspective, as, folks who are in this position, they were like talking in disability rhetoric like that, and ableist rhetoric like that. In this way, they did not find problematic, and they kind of supported the language choices that I'd made in that they understood that why I was doing them and saying that actually isn't a problem in this context. So it was nice to hear from people from all sides explaining how they felt about it so I could develop a better picture. One more interesting comments that was made was from somebody who said that the use of disability rhetoric wasn't actually a problem, but the thing they did have an issue with that they wanted to point out to me, which I've already used in the context of this podcast, now that I think about it, is they said that I should have been more concerned about using language like moron, which we use colloquially for people who do things like write posts that say, "You're wrecking my curve." However, the term itself began as a clinical definition for people who had certain mental conditions. And so its usage as something that, to denote dumb decisions kind of is actually reinscribing that kind of some kind of ableist rhetoric, which I thought was interesting. And it does put you in a weird place because I think that's probably true that a lot of that language came from there. But on the other hand, there's some level to which we're getting so divorced from that original meaning that does it still ring true? And certainly it's not something that would strike me off the top of my head as ringing true like that. But it's also something where, of course it doesn't, because I have the privilege of not thinking about that every day. So it did kind of inform how I think about that and where I use it and why I use it and whether or not that's a problem. It's important to just always be thinking about these things, even if you aren't making a change, right? Like as a person writing out there, to have it front of mind, even if you go forward with it, it's still important to be cognizant of it,
And one of the things that I kind of think is very interesting about this dialogue that you were able to have with the readers is that even though, at Above the Law, we closed comments about 3 years ago now, even though we don't have comments, we still are able to have dialogues with our readers, whether we have our email just as widely available on the website. We all have social media, Twitter, all of that kind of stuff. But I think that what we're finding largely is that old-fashioned comment boards are very much a relic of the early 2000s and not something that is super necessary for websites in the late teens.
Yeah, I will say that I had far more engaging and valuable conversations about this because people took the time to engage directly rather than have to fight through the boards that, I don't know if people remember the old Above the Law boards, but there was a lot of like, you're dumb, fat, blah, blah, blah. That would be something.
Those are the more benign comments that used to be on the ATL comments.
Right. I mean, there was lots of sexual violence, obviously.
Just
stuff
terrible
like that.
stuff.
So, yeah. And folks who even wanted to have a constructive conversation in that board were always drowned out by all of those comments. I think that we have obviously it requires more active work on the writer's part. And back in the day, the comment boards could exist and people could feel like they've said their piece, whether or not we ever looked at it or not. But now, if somebody does, at you on Twitter, you do have to look at it, evaluate it, engage it. And that's something that I think has actually made the conversation better. It makes it a little less, you have a little less self-aggrandizement by being able to say, hey, look, that's my name there, calling Ellie a walrus, which was a thing that happened a lot. But you don't have that, but you do have the ability to talk to us. It does require us to, read our emails and respond, but I think that we're pretty good about that.
Yeah, and I think we had a recent story, I'm pretty sure you wrote it, about, some of the legal internet or commenters, even though, at ATL we've closed the boards, that they really have found other homes kind of across the internet. Yeah,
the poor ABA Journal has, they never got rid of their comments. They're still there. You have to affirmatively click to enter them, which is a practice that even we were doing at the end. But yeah, and you have to click to enter them, but they have also, inevitably taken the turn. And while there are people there trying to have good, substantive, intellectual engagement with the stories that the ABA Journal's writers are actually writing, they just keep getting derailed by all manner of awful stuff. Mostly weird conspiracy mongering people who then, incite everyone else to fight them. And even those fights get more and more aggressive and, reaching the point of violence. And they're just kind of poisonous places because they reach out to the lowest common denominator, who unfortunately has the power to ruin everything for the people trying to have a good discussion.
Yeah, I mean, I think that once you're writing something on the public forum that is the internet, you're kind of become a beacon for all manner of people, right? Anyone with a phone or an internet connection of any sort can read and comment and respond to your stuff. And I think that what lots of different publications are trying to grapple with is what is the best way in order to have the conversations. Is it on forums like Facebook or Twitter that are kind of third party, that at least have some sort of a name attached to them, versus these sort of anonymous comment boards, which is something that we had at Above the Law back in the day. And it's kind of an interesting dichotomy as we're going forward and trying to, figure out what's the best mix for, not just for the sanity of the writers, because, whatever, we signed up for this, but, also for folks who are interested in engaging in a lot of these questions.
Yeah, it just fundamentally struck me that this is not the publication's job.
Right.
Like, you don't run your own fan site as, if you were a celebrity, right? And that's kind of what it's like. Our job is to put out a product that the millions of clicks will like. And whether or not they like it, or that I shouldn't say like, that they will read and consider, whether they like it or not. And at a certain point, maintaining those boards that were only frequented by a handful of people, that's resources and time and energy that takes away from the actual audience. And you just have to recognize that that's not our job. If people want to engage in those stories in another forum, we have forums like that. Places like Facebook and Twitter, they exist solely so people can make commentary about things. That's not what we are doing. And so, follow Above the Law on ATL, at ATL blog on Twitter. Follow us on Twitter at Joseph Patrice, at Kathryn1, whatever. Or wait, you're Kathryn1, right?
Yep, at Kathryn1.
Yeah. At Kathryn1. Follow, be a fan of the site on Facebook, whatever it is. But those are the forums where third parties run them to have that discussion. Don't expect that we're going in a position, frankly, to take the time to maintain a space for people to talk about the site. Our job is to have the site, not to host the place where people can talk about it. And so to close the loop, that's the thing. The ABA Journal's kind of in that place that we were a few years ago, where they had these great conversations that are getting derailed. And so when I saw it, I was very I felt kind of a
sympathy.
pang of, I feel where you are. And then I also felt a bit of guilt because, I mean, I'm sure these are people who would otherwise be on our site complaining before we closed ours.
So, Joe, we're at the end of the year, and I have to ask you, what was the best legal story of 2018 in your mind?
We're actually into the whole new year.
It said of 2018. Like, what was the legal story that spoke the most to you?
I mean, I don't know, spoke the most to me, like that I most enjoyed. Like they're kind of all over the place. I mean, the legal story of the year was the various actions of the Supreme Court, the like loss of Kennedy and the whole Kavanaugh kerfuffle. The story that I enjoyed working on the most was probably the Schlossberg story, which was the random lawyer shouting a bunch of racist stuff in Midtown Manhattan, and then the fallout from that. That was the most kind of fun I had, like following a story from its
early
birth
moments.
to, yeah. I had a lot of fun this year following the various cases. Again, like, I don't know, like it depends on what you're saying, but I mean, those are two that crop out to me.
For me, I think that, one of the big stories that sticks out in 2018 is the big law raises. I think a core of the Above the Law audience is always going to be concerned about what's going on in big law. And, when Milbank decided to raise salaries across the board, not a ton, mind you, but enough to kind of move the needle. And then Cravath came over the top at least for senior associates, and Simpson matched those numbers and then also added in a special summer bonus, which, Milbank and the rest of them eventually matched all of those numbers. I thought that was a really exciting time for those who follow the ins and outs of the world of big law.
Yeah. No, I mean, that's a good one, too. Like, the legal industry news of the year was definitely the raises and the way in which it's pushed the whole industry a little bit further down the line of a reckoning, I think. Like, I do feel as though there's a flattening especially at the top, where, you're getting the same giant salary in certain I'll pick on Houston again, in Houston as you are in New York City. And, at what point does that break? And I think we talked about this in 2016, and now it just got a little more acute. So,
yeah.
Anyway, cool. So thanks for, pinch hitting for us here with Ellie not around.
Anytime.
Cool. That's Kathryn Rubino. She's at Above the Law. She also is the host of her own podcast called The Chabot, which talks about a lot of these issues about women in law and
diversity and identity,
discrimination, and yeah. So thanks for listening. You should read Above the Law as always. You should be following all of us on Twitter. I'm at Joseph Patrice. He's at LENYC. Kathryn's at Kathryn1. You should be following the Above the Law Instagram account, which I gather we have. Not that I've been very active in it, but I know that it's out there. You should be subscribed to this podcast. You should be giving it reviews, all those sorts of things. You should check out Smith.ai, who, again, thanks for sponsoring the show. And you should be listening to other Legal Talk Network shows. There's a bunch of them. I sometimes host on the road whenever we find ourselves at a convention together. So, there's some episodes there. There's obviously Thinking Like a Lawyer and a bunch of other good ones out there, too. So check them all out. And with all of that, I think we're done. We'll talk soon, everybody.
Bye.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. You can also find us at AboveTheLaw.com, ATLRedline.com, iTunes, RSS, Twitter, and Facebook. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.